Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Robert E. Temmerman Jr., who I'm just going to call Bob. And anyway, Bob is an attorney. He specializes in estate planning, incapacity planning, and estate and trust administration. He has his own law firm, Temmerman, Silly, and Coleman, here in San Jose, right across from Valley Fair. Anyway, he is the managing partner and founder of the firm. He received a BA in Economics and Political Science, magna cum laude from Boston College in 1975, and his Juris Doctor magna cum laude from Santa Clara University in 1980. He is an active speaker in the estate planning community, and we have an upcoming event here. Today is September 20th, is the Jerry Kasner Estate Planning Symposium, which is a gathering of eagles here in Santa Clara. So it's sort of an event that we're proud of being involved with, and Bob spoke every year, I think, for that event.
Pretty close.
Almost pretty close. Anyway, he's contributed chapters to books, including California Estate Planning, published by the Continuing Education of the Bar. He's also participated in writing the rules of the court for Santa Clara County Probate Court. I saw the judge is asking for comments here just recently. And so he's obviously quite involved in the professional community of attorneys and advisors from around the country. But Bob is also an avid cyclist, and he's quite an athlete. And in 2009, he rode his bicycle 4,300 miles across the U.S. and Canada. He tells me he's getting ready to do a cycling trip for a few weeks in New Zealand. He also heliskis and plays amateur adult hockey. So anyway, Bob, thanks so much for joining me today.
Thank you, Mike, for having me. It's always a pleasure.
Yeah, thank you. So today our topic is, I'm an executor. Now we talk about this from time to time, but I'd like to bring it to our viewers' attention again. You know, these things happen, and so this role may come before you as to whether you may be an executor. We'll talk a little bit about that. As we get started, though, I do want to caution our viewers to consult with an attorney when administering an estate, and that we want you to do that. This is just a little taste of what you have to deal with here, an introduction, and it's intended to be a way to get started talking about these things with your own attorney. Also, Bob is a California attorney. I'm a California CPA, and so there are special rules that apply from place to place, even place to place in California. We talked about rules of the court here in Santa Clara County. They have rules of court in other places that may be somewhat different. Okay, Bob. So a lot of people have heard this scary word, probate. Maybe you could tell us a little bit about what it really means.
Sure, Mike. Probate in its simplest form is merely the process that takes place following the death of an individual when one dies with a will and with property titled in the individual's name. It's a court-supervised process. The process includes appointing a personal representative or an executor of the estate, giving notice to all those that are entitled, doing an inventory of the assets, an accounting, and ultimately a final distribution. The reason it has sort of negative connotations is, at least in California, it's a costly court-supervised process, and for the most part, it can be avoided. And it's really, probate is optional now. If you don't do any estate planning, you'll be in probate. If you do any sort of estate planning, most good planners will keep you from having to go through that court-supervised process.
Right, and then in smaller estates, you don't even really have to go through probate either, isn't that right? Or
Excuse me. If the estate is under $150,000 of value, you can use affidavits to collect assets that are in the decedent's name. There's a requirement of 40 days waiting period post-death before you can collect it. But other than small estates, if you owned real estate in California, unless it's a desert lot in Lancaster or Riverside County or somewhere down there, it's unlikely that you'll be able to avoid probate.
Okay. Okay, so if a decedent has a living trust, does that automatically mean that no probate is required?
Let me step back and answer that by what's a living trust, because the terminology is important.
Okay.
A living trust is a trust created by an individual during their lifetime, hence the word living trust. And living trust came into vogue back in the early 1980s when they first began using them as probate avoidance techniques. So if you create a revocable living trust, and if you fund the trust, meaning you actually transfer assets that you own to the trust, the law says that the assets are not subject to probate. They are subject to being administered under the terms of the trust. What we've found in practice, Mike, is that a lot of clients have living trusts, but they have not funded the trust properly, meaning they have not taken the time to transfer their home into the title of the trustee of the trust. And as a result, oftentimes there is a probate still, or a process that we may need to utilize to either probate the will of the decedent to get the assets to the trust, or something more common that we do is there's a petition called a Hegstad petition, that if we have evidence of the decedent's intent that he wanted these assets in his or her trust, we can kind of go into court for a one-shot, give me this order, judge, please tell me that my home is in the trust. And you get that order, and that will keep you out of probate.
Okay. And I've heard that there are some cases, or at least attorneys have told me in the past, where they decide to sort of probate for other reasons, although I understand also there's other processes maybe that are more recent developments. What I'm talking about is, you know, if there's a liability exposure, say for a doctor or somebody that has that type of a scenario.
So what you're talking about, Mike, is kind of opting into a probate process, and are there advantages over not doing it? And it's really, if you're going to opt into probate, you would do so for a couple of reasons. One might be to flush out any creditor claims. So you might open what we would call a dry probate, give notice to all the heirs and reasonably known and ascertainable creditors for the purpose of shortening the limitations period from which a creditor can file a claim against the estate. So if you give notice to a creditor who's known and reasonably ascertainable, they basically have 4 months from the time an executor is appointed to file their claim. In a living trust scenario, unless you opt into an optional creditor claim notice provision, which not a lot of people do, you have basically a statute of limitations that may be a year. So there are circumstances where you might have potential claims where it might be advisable to open up a dry probate just to flush out creditors.
Okay. Let's say a husband had a will, dies, he leaves all of his estate to his wife, and all of their property was community property. Do you need a probate then?
Let me answer that by first kind of defining community property for your viewers.
Okay.
Community property is property acquired by a married couple during the course of their marriage as a result of one's time, labor, effort, and skill. And so hence that's property acquired from your wages, your compensation, things of that nature. And California law says that community property is owned 1/2 by each spouse. So at the time of death, the deceased spouse owns half of the community property and can control half of it. If he or she left it all to a spouse, we have an expedited proceeding in California called a spousal property petition. This is a petition that's, again, kind of a one-stop into court. Your Honor, these clients were married on such and such a date. They acquired all of their assets post-marriage. Please give me an order that it's all community property, and give me an order confirming that it all passes to the surviving spouse. There are two benefits to that order. It's not a full-blown probate, and so it's an expedited proceeding. And two, you actually get a judicial determination that the property is community property, which gives you a double step up in basis for income tax reporting purposes. It wipes out all unrealized capital gains that had accrued up until the moment of death.
Okay. So, and when we say double step up, we're saying both the decedent's share and the surviving spouse's share are both being adjusted at fair market value at the date of death. There was another little thing. So you mentioned that for married couples, but in California we also have registered domestic partners.
You get the same tax treatment for registered domestic partners in light of the Supreme Court's rulings in the past year, and following up on those rulings. There are fewer and fewer registered domestic partners because now you can be married, same-sex couples can be legally married in all jurisdictions.
Right. Okay. So here's another thing that scares people. It has to do with the statutory probate fees. So are they really horrific, and can any other fees be charged by an attorney or an executor in addition to the statutory fees?
There's a perception in the community, and it's probably well earned because our statutes have not been changed in years.
Long, long time.
The fees for the attorney are based upon the size of the gross estate, not the net estate, but the gross estate being administered. And they're a percentage of that estate. In California, it's 4% of the first $200,000, 3% of the, I believe it's the next, it might be 800,000, 2%, and then 1%. It's a decreasing percentage. But bottom line is, if you had a house worth $750,000, which in Silicon Valley is not uncommon, in fact, that's less than the median, and you had a few other bank accounts and a retirement plan, you're probably at $1 million estate, and the minimum legal fees for probating that are $22,150. So it's a pretty significant cost. If we were to charge hourly to administer that, it would be substantially less. But those are statutory fees. In addition to the statutory fees, if we have to do what are called any extra special or extraordinary services, the court has the discretion to award counsel and the executor fees for extraordinary services. And this would be for such things as running a business, sale of a residence, or any sort of litigation that the estate had to face. Then the court has discretion to award additional fees. So it is an expensive process, and clearly one that most clients, given a choice, would prefer to avoid.
And of course that, again, has to do with the popularity of living trusts. But we're going to have a separate program on being a trustee. So what happens if a decedent dies but doesn't have a will?
That's called dying intestate. And dying intestate just simply means the decedent did not have a will, didn't take the time to write one out or engage counsel to help prepare one, in which case California has decided to give you a will. And it's a will that says, in the event of your death, if you die and you don't give any direction as to what you want to do, California has an entire statutory scheme as to who's entitled to receive your estate, right down to the sort of the last resort heir, which is the state of California. And so intestate succession is by statute. It would track what the legislature has deemed what most people would likely want to do. If you died intestate, your community property would go to a spouse. Any separate property inheritance you acquired would go partly to a spouse and partly to children, if there were children. And it goes down the line before it goes back up the line. But there's an entire statutory scheme that will tell you who's going to take that property.
Right, okay. Should you keep some sort of a cash reserve, like me, have a cash reserve for incidental items at death, just to have some funds on hand?
It's not uncommon. I think what you're saying is,
And can they get it?
yeah, what's the process from getting an
Yeah.
executor appointed? And that process can be as much as 2 or 3 months post date of death. And that's assuming we find out right away. By the time we can get on the court's calendar and get an executor or an administrator appointed, it could be a few months down the line.
Right.
Well, in the meantime, there's funeral expenses and other expenses that have to be met. So we will oftentimes counsel clients, if they're not doing a living trust, because you'll have immediate access to those assets, to keep a small bank account with whoever you entrust to administer your estate, a spouse, a child, or something of that nature, so they do have immediate access to a joint account to meet some of those expenses, and then they can be reimbursed from the estate.
Yeah, okay. What is an executor? What is an administrator, and is there any difference?
There's only a difference in name. An executor is the individual who's been nominated in a will of a decedent and appointed by the court as the generic term would be personal representative. So the person in charge of the estate under a will is an executor. Mm-hmm. The administrator is a person in charge of the decedent's estate where the decedent didn't have a will. So there is no will that nominates an administrator or an executor, and hence the court appoints an administrator as the personal representative. They have the same fiduciary duties, the same obligations to the beneficiaries. It's just an executor is under a will, an administrator is the decedent died without one.
Okay. Now, if you are nominated as an executor, do you have to accept? And what sort of things do you think that people should think about before accepting?
And I think that's an excellent question, and generally the first topic of discussion when I'm meeting with clients in a post-death scenario. When an individual nominates someone as the executor, it's merely that. It's a nomination. You're not an executor until the court tells you you are. So your first decision is, do I want this job? Is this a job that I want to undertake? What are my duties? What are my responsibilities? How time-consuming will it be? Are there potential liabilities out there if I assume the role of the executor? So it's important for the nominee to understand that it's not all a big fee. There's actually a lot of work that our executors have to do. And so we go through that with clients, and unless the client has some high energy level and has the availability of time, we'll counsel clients that you can decline. You do not have to accept the role, but if you do accept it, we expect you to get the job done. Do not procrastinate.
It can be a really tough job, and emotionally, especially, well, you can have conflicts in the family and so forth. So there can be very good reasons why you don't want to take this thing on.
I've often told clients where there's really dysfunction in the family and other characteristics that are less than desirable among the beneficiaries, that in essence they're looking for someone to blame. And they can't blame the decedent because he or she's dead, but they'll blame the executor. And so you're wearing a target, and that target is a target that if you make any miscues or missteps, they'll go after you.
Yeah. What are letters testamentary and letters of administration?
Again, this is vernacular for a very simple term, magic papers that allow you to gain access to the decedent's assets. So letters testamentary are a document that the court issues and certifies, which is proof to the financial world that you are indeed the court-appointed executor under the decedent's will. Letters of administration are the same document, but you're not the executor, you're the administrator. And you use this paper to go down and close out the decedent's bank account and open up an estate account and access any of the other brokerage accounts or financial records of the decedent's from any financial institution, a title company, things of that nature. It's proof to the world that, in fact, you are court-appointed and recognized by the court as the person in charge.
Okay. What's the significance of a death certificate?
Well, the obvious is, okay, the person is really dead,
Uh-huh.
and it's certified by the county in which the decedent resided, but it's oftentimes necessary in many situations to access an account that might have multiple parties on the account to prove to an institution that the participant in a retirement plan has passed and now we're moving those assets to the designated beneficiaries, to collect life insurance proceeds. It's used for a variety of circumstances. You know, we try to tell clients, yes, we're going to need more than one in most cases, but maybe we don't need 30 given the cost of each certified copy. We look at the number of assets, which ones are likely to require a death certificate that's certified, and try and give them a good idea. You know, let's buy these for now, and if we need more, we can get more later.
Okay. What notice requirements apply for probate estates?
Well, there are a lot of notice requirements in probates and in any sort of decedent estate administration. Probably the most important one is the notice to creditors, which have to be, under the U.S. Supreme Court Tulsa decision, have to be given to all known and reasonably ascertainable creditors. So if you know, or you could find out by reviewing the decedent's books and records, that there's a potential creditor out there, you have a duty to give them notice so they can timely file their claim. In addition to that notice, California has some notice requirements, such as notice to the Victims' Compensation Board if the decedent was ever incarcerated or had any sort of a judgment against him. There's notice to the Department of Health Care Services for any sort of public benefits the decedent may have been receiving via Medi-Cal or otherwise. You've got to give notice to the Social Security Administration for survivor benefits and to terminate any sort of Social Security benefits that the decedent was receiving. So there's a variety of notices that the executor must provide following a death.
Right. How long does it usually take to probate an estate?
Well, our fast ones, we can generally get done in about 6 months from the time they are appointed to the time we close. And so that's, you know, we can probably get somebody appointed within a couple months after death if we can get on the court calendar. And then there's a minimum 4-month statutory waiting period for any sort of a contest to be filed. And then we can close the estate thereafter. So our quickest estates are probably open and shut in 6 months. On average, I try to tell clients realistically, in many cases it's going to be 6 to 9 months, and in some cases it may be a year or longer, depending upon the nature of the assets and the difficulties that we encountered during the administration.
Okay. Now, for many people in their personal accounting, first of all, these days it seems like people aren't even keeping checkbooks. I hate to say that, but anyway. My son doesn't have a clue. The accountant's son, right? But a lot of people, for example, even when they keep a checkbook, they'll just write their total deposit down in their checkbook and things like that. So what about for an estate? What do you need to do for an estate?
Well, your son is able to do whatever he wants because it's his own money.
Right.
As a fiduciary that's appointed by the court, you have duties and responsibilities. One of the duties and responsibilities is to do an accounting during the period of time that you are the executor, and that means you have to account for every penny that comes in as well as every dollar that goes out. And the accounting can be waived and oftentimes is waived by the heirs and beneficiaries. But in the event that not everyone agrees, that accounting, you have to keep very, very good financial records. And that means we're going to want to see copies of the bank statements from every institution, brokerage account statements. We need to track every transaction.
Right. And part of the issue is that these days a lot of people are doing things online.
It's becoming an issue in the digital age that we live in, because oftentimes the decedent doesn't share a password or doesn't share, as they shouldn't, information to be able to obtain this information readily. We've started a process of saying, I don't want to know your passwords, I just want to know where your executor can find a log somewhere in your house to be able to access your email account, your financial digital statements, things of that nature, because it's important if you're not getting anything through the mail anymore.
Right. I mentioned the thing about the deposit. So one thing that an executor should do, that I would always recommend, is make copies of all the checks that you're depositing, so that you've got that reference, and that's part of it. It's just like not keeping a copy of an invoice. You also keep a copy of the deposit
Right,
details.
and the source of the deposit. Where did it come from?
Right. Well, Bob, believe it or not, time has flown. It's unbelievable. This is a big subject that we're talking about. That's why you're in business. And so, maybe that's like I'll just say they're telling me to wrap up. So, Bob, thank you for joining me as my
Mike,
guest.
it's always a pleasure.
Okay, folks, see your attorney. Hopefully we've given you some ideas of things to talk about. See you next time on Financial Insider Weekly.